Supreme Court partly allowed the appeals filed by appellants or owners, limiting its interference to the extent that appellant number 2 minor is absolved of any involvement in accident. However, respondent insurance company shall not be absolved of its liability and direction against regarding recovery by its set aside. The facts relevant for disposal of present case were that deceased Vijay Jumnalkar, husband of first claimant, father of second claimant, and son of third claimant, along with his friend Ravi Vasnath Gaurav, had been to Vijayanagar, Belagavi, to meet one of his acquaintances. When both of them reached the road near Atvadkar layout, Vijayanagar, offending Bolero vehicle being driven by its driver in rash and negligent manner and in high speed, came from Sanadhan residency towards Atbadkar layout and dashed out against the deceased. Deceased was dragged to some distance and on account of said impact, he died on the spot. Subsequently, FIR was lodged by Ravi, who stated that appellant number 2 or minor was driving the offending vehicle. A forced FIR was challenged by owner of offending vehicle in criminal petition, but same was dismissed by High Court. Learned counsel vehemently argued that appellant number 1 was registered owner of offending vehicle and it was being used by appellant number 1's friend, father of appellant number 2, who had paid insurance premium and had valid driving license. While acknowledging occurrence of incidents, appellants argued incident was caused due to negligence on past part of deceased. Additionally, it was contended that appellant number 2 was minor at time of occurrence of incident, was not involved in accident, and he was merely seated beside driver, being the son of appellant number 3. It was further asserted that father of appellant number 2 was the one who was driving vehicles at time of accident. However, despite this, false criminal case had been filed against the appellant minor and his father, accusing them of offences under section 279 3 and 4A of IPC, in addition to violations of section 5, 4, 180, 181 and 184 of Motor Vehicles Act. Further, it was argued the respondent or the claimants, in collusion with the police officers, have managed to file charge sheet against minor. Moreover, owner claimed that respondent numbers 1 2 were entitled for reasonable compensation from respondent 4 in view of contributory negligence on part of the deceased Vijay himself. Per contra, learned counsel, respondent number 1, deceased wife, and deceased mentally disabled son and deceased elderly mother submit that findings of courts below were well founded and courts below have rightly appreciated evidence on record concerning negligence of appellant owner which resulted in the accident and death of the deceased. It was further contended that respondent number 1 is widow of deceased is unable to earn her livelihood as she cannot leave respondent number 2 her mentally disabled son unattended or her disabled son requires constant care, attention, and service due to condonation of compensation awarded by court, and the courts below deserves enhancement. Court earlier in Sajina Iqbal versus Mini Babu George had occasion to examine evidence on record in appeal filed on Article 136 of Constitution. Before proceeding to dwell on merits, court said that we remind ourselves that present case is an appeal under Article 136 of Constitution, wherein ordinarily this court would not reappreciate the evidence. However, court in Manglaram versus Oriental Insurance Company Limited held that it is an appeal under 136 of Constitution. Ordinarily, this court will not engage itself in reappreciation of evidence as such, but can certainly examine evidence on record to consider challenge to findings recorded by tribunal or high court being perverse or replete with error apparent on face of recording and being manifestly wrong. It was consistent case of appellant from beginning that minor was not driving vehicle at time of accident. It was asserted that minor had merely occupied a seat beside the driver. RW2 deposed that accident was caused on account of negligence of deceased Vijay, who, while talking on his mobile phone, abruptly appeared in front of vending vehicle. RW2 denied allegations made by respondent claimants regarding accident, maintains that neither he nor minor son were responsible for accident. Court said that we find that beyond judgment and order passed by courts below do not warrant any interference in so far as award of compensation is concerned. The compensation awarded by courts below was upheld. However, primary issue that necessitates further consideration is question of whether appellant number 2, who was minor at time of incident, was actually involved in the accident in question. In order to arrive at just and fair conclusion on this issue, it becomes imperative to closely examine and analyze statements of witnesses who were produced and examined before tribunal as well as other relevant pieces of evidence. In present case, court said that we observe that courts below have committed a grave error in failing to properly appreciate the evidence presented by appellants in determining who actually was driving the offending vehicle at time of accident. Thorough examination of record makes it clear that following crucial aspects of evidence indicate that it was father of appellant who was driving vehicle at material time and not minor. Both tribunal as well as High Court have committed grave error in not considering vehicles in evidence in true perspective and have misguided themselves to record perverse findings regarding involvement of minor in the accident. Findings recorded by the lower courts regarding the alleged involvement of appellant 2 or the minor in the accident were therefore unsustainable in law.